How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy Hump Day. Hopefully you guys had a great start to your week. I don't know why I'm saying that. We're halfway through the week. Yeah. You guys, I don't know what else to say. You guys want to watch some court? I want to watch some court. Let's watch some court. I've got some randomness tonight. See, Judge Dad, Judge DiSanto, Judge, is it Irochi? I don't remember how to say his name. Anyways, we're going to be bouncing everywhere. Let's just get into it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick back flips. Let's go.
Paul Joshua Tyson, 250-720-272. Okay, your name again?
Detective Lieutenant Steve Mercury, Rockwood Police.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Okay, go ahead.
Your Honor, 8:25 of 25 at approximately 10:30 in the evening, officers Frierson and Harshbarger with the Rockwood Police Department was dispatched to the Rebel Gas Station, 22855 Hanover Drive in the city of Rockwood in reference to a VIN verification. Upon the officers' arrival, they spoke with Todd Taylor. Taylor stated he spoke with a subject by the name of Timothy on Facebook Marketplace, who was currently selling a white 2009 GMC 350 heavy-duty pickup truck with a VIN number of 1 G George, T Tom, J John, K King, 83699 F Frank 136375. Mr. Taylor stated that he was purchasing the vehicle for $9,500. However, when he looked on Kelley Blue Book, the value of the pickup truck was over $19,000. He thought it was suspicious in nature and requested that the officers do a VIN verification due to the suspicious nature and the sale price of the vehicle. The officers ran the VIN through Lean SOS, and the vehicle currently came back as a stolen vehicle out of Old Bridge Township, New Jersey. Shortly thereafter, the vehicle pulled into the parking lot of the Rebel gas station, and the driver was identified as Paul Tyson. Officers confirmed the VIN number that was attached to the vehicle, as well as Mr. Tyson had the title to the vehicle as well. When Mr. Tyson stated that he was selling the vehicle for a family member, when officers asked what was the family member's name, he refused to answer at that point and requested an attorney. A lien check confirmed that the vehicle was stolen out of Old Bridge Township, New Jersey. And when I spoke with the detective in Old Bridge, she stated it was a sale went bad there where it was used a fraudulent check to purchase the vehicle. That's why it was reported stolen. I also did a value of the vehicle check through Kelley Blue Book myself for the value of the truck by VIN number, and it showed that the value of a private sale is $19,855. I submitted a warrant to the Wayne County Prosecutor's Office, and you have a charging document in front of you.
You have these prior convictions here, February 8 of 11 for robbery armed and felony firearm, and also September 22 of 22, retail fraud first.
Yes, Your Honor.
Based on your sworn testimony, I find the crime of receiving and concealing motor vehicle was committed. There's probable cause to believe the crime was committed by the defendant, and that the defendant has the prior convictions giving rise to the habitual fourth offense notice. So I'm authorizing, I'll note you signed, I'm signing and dating the complaint and the warrant for the arrest of the defendant. All right, so Mr. Tyson, your name, sir?
Paul Tyson.
Okay.
Sure, with name's Paul Tyson, we wait before reading statement.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. Again, if you cannot afford one, I will appoint you one at public expense. Also, if you choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. That will take place September the 9th at 8:45. Preliminary exam, September the 16th at 10:30. Those will be in front of me. And I want you to understand, if you're convicted of a 5-year felony, which RNC motor vehicle is, since you have allegedly the 3 prior felony convictions, you could get life. Do you understand that?
Yes.
All right. So September 9th, 8:45, September 16th, 10:30. You can go ahead and address bond.
Thank you, Your Honor. With regard to those priors, Mr. Tyson tells me that he served 10 years on the 2011 matter, and then successfully completed parole. And he's currently on probation to Oakland County on the 2022 matter. He said he was set to be released from probation September 22nd, so it's coming up shortly. He indicated he's had some health issues. He had a major surgery in December. Has been unable to work since then. He is requesting court-appointed attorney going forward. And with regard to the bond, he indicates he really has very little money, and anything over 2,010%, he probably is going to be in custody until the next court date.
Lieutenant, what do you have to say? Does he have any holds, any other convictions?
Your Honor, he's got a few traffic warrants. Other than that, just what we already stated in court, but I'll leave it to the court's discretion.
You said he's got some traffic warrants?
I believe so, Your Honor.
I'm sorry?
That's Your Honor, he's got 3.5 pages of them.
Yeah, you got 8 warrants, 9 warrants. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. No contact with Robert Ida or Todd Taylor. No contact with either one of those individuals. Also, no contact with prosecution witnesses. 20,000, 10%. You got to show up in court, sir. You can't have multiple warrants and expect a personal bond. 20,000, 10%. You're going to have to post $2,000 to secure your release. September 9th, you'll be back in front of me. Any questions? Any questions?
Yeah. You said 20,000?
20,000, 10%. Yes, sir. You got to show up in court.
I show up. I always show up.
You got 8 warrants. No, you don't. You got 8 warrants. Come on. Don't argue with me.
Okay.
You got 8, I think 9 warrants, actually. Good luck to you. You got to show up. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
David Maurice.
All right, that was a good way to start the night, right? We have a guy who allegedly stole a truck, tried to sell it. Now he's begging for a PR bond. Didn't get it because he has 9 warrants out for his arrest. Yeah. So that's fun. Great way to start the night. Okay. Real quick, Vic. Thank you so much for the super chat. I appreciate it. Mary Smith, late fee. I haven't seen her here yet, so she must be late. I haven't seen her yet either. Vic, I have not seen her, but thank you so much. Maybe we just Beetlejuice her. Hold on, I need to say her name 2 more times. Mary Smith, Mary Smith. Okay. That's 3. That's 3. Let's see if it worked. Okay. Let's move on to the next one.
The Divine Call 23210.
Morning, Your Honor, John Gold, for plea 0758 on behalf of Mr. Cole. Mr. Cole, please put your name on the record.
Demont Cole.
All right, good morning. Okay, so today's date scheduled for the adjourned probation violation hearing. It's alleged you did not appear for custody on July 15th and July 16th. And Kelko?
Your Honor, excuse me. As to the violations, he would waive formal reading of those violations and stand mute, and he would plead guilty to the violations.
Okay, well, I did do the arraignment of not guilty.
Yes, you did, I'm sorry.
That's okay. Sir, please raise your right hand. You solemnly swear from testimony about to give this man the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, and you heard the allegations, sir, that you did not appear for custody July 15th and 16th. As to those allegations, sir, how do you plead?
I plead guilty, ma'am. I plead guilty.
And you've gone over your advice for probation violation purposes, correct?
Yes, ma'am.
And you understand all of those rights?
Yes, ma'am.
And you understand by entering into a plea that you'll be waiving some of those rights?
Yes.
And you understand the possible penalty as a result of your plea? As a recommendation, this matters for probation to be revoked. Case closed without improvement. $50 probation violation fee, 15 days jail. You understand that?
No, I did not know any of that.
You're not telling that part, and I apologize.
Well,
You know, I didn't know any of that.
You understand that the recommendation, it's only a recommendation, is for close out probation. I know you've been on it for a period of time. There's been a number of reviews. You've been doing very well along those lines. And so, but the recommendation is to 15 days in jail. I'm not suggesting that's going to happen. I'm just suggesting that's the recommendation.
Okay. Okay.
Okay. And knowing all that, sir, you want to continue with your plea?
Yes, ma'am.
Anybody promise you anything, threaten you, or force you in any way for you to enter into a plea?
No, ma'am.
And counsel, part of your client.
Thank you. Mr. Cole, you were placed on probation to this court, correct?
Yes, ma'am. Yes, sir.
And one of those terms and conditions was that you were to test when directed, and there are 2 occasions when you did not test. Is that correct?
Yes, sir.
And those 2 dates were
July 15th.
July 15th. And you did contact the court regarding your failure to test on that day, and then
Yes.
going on the 16th, and you failed on the 16th test. Is that correct?
Yes.
Been satisfied with that, Sean?
The court is also satisfied that there is no involuntary and factually accurate. The court will accept your plea to the amended charge, or to the probation violations. And, counsel,
You know, as to
I'm
the
sorry, indicate technical violations 5 and 6 have occurred.
as to the recommendation, Your Honor, Mr. Cole has been before this court. He's gone through a number of jail reviews. He's done a very good job, I believe, in resolving these problems. This was an isolated incident. I know there were prior ones where he failed to appear. He did show up. He had some car problems, got up there late, and of course that wasn't acceptable. He did contact the court, told him to go in the next day. He had.
And then you have the opportunity to not have a violation.
I
You
understand.
didn't go in on the 16th.
I
And then your client didn't even go in on August 1st. We didn't have that as a probation violation, but I'm just giving you that as
I
information.
wasn't aware of that, Sean. And when the next day, he had to get his son to, he was still having car problems. He didn't have transportation, so he was able to get a ride the day before. He also had to get his son to the doctor. There were a lot of extenuating circumstances. It wasn't like he was trying to avoid testing because he's been clean of all the other tests. I asked the court to, rather than implement his employee, taking care of his son, that at this point in time, the 15 days, I think I would rather think that what we should do is, rather than revoke the probation, is to give him another opportunity to show that his testing is clean. And the 15 days, it wasn't intentional. It was intentional only because of the circumstance. Do you have any to say, Mr. Cole?
Yeah, I always drop clean. I drop at least twice a week. It wasn't intentional for me to miss a drop. My crown went down the first day, and then the second day, I had to take my son to the hospital. So I had to spend hours at the hospital, and I'm not gonna lie, I had to catch a lift to the hospital. So a lift to my house was like $70. A lift to from my house to get back to the drop site, it was like probably $60, and then probably another $60 back. I'm not gonna lie, I didn't have the money that day. That's just being honest, man. I didn't have the money to, especially with me having to get a tow truck the day before, having to get a ride to the drop site the day before too. And then I just didn't have the money. I'm not gonna lie to you. I didn't have the money at the moment, man. I didn't.
Two things, sir.
I don't know. I think there's a lot more than two things. But I'm glad he's not going to lie. He's not going to lie to us, guys. He's not going to lie. He's not lying. He told us that about 5 times that he's not going to lie. Phil, thank you so much for the Sparkle Poots late fee. Thank you, Phil. I appreciate it. Then Jedi coming in. Meemaw late fee. I think that's the same person. So Sparkle Poots got 2 late fees tonight. Thank you both. I appreciate the super chats.
You're telling this court from that your home in Wyandotte to the testing facility is a $60 lift ride.
No, I said from the hospital to my home is a $60 lift ride, and then I have to get from my home to the drop site. You know?
Okay. Did you at any point submit any documentation regarding your son's hospitalization?
Do I have any documentation? Yeah, I can find it here.
Sir, your responsibility is to submit that at the time that you missed your testing.
Okay.
I don't know how much more oversight I can do for Mr. Cole. I mean,
Understand.
we're on the third hard ROA here in the file. And the court had Mr. Cole on a jail review, right? Because he was having an issue with his counseling and not getting into counseling. And so the court wanted to make sure that that was occurring. There were on technical violations 5 and 6. 15 would have even been a violation had your client gone in on the 16th. And then, sir, if you couldn't go in on the 16th because you were at the hospital with your child, then you needed to submit proof of that. And even still, on the August 27th, still, there's 0 proof that's been submitted to this court. 0. What time did you go to the hospital with your son on July 16th?
You said what time did I go?
Yes.
He had 2 appointments that day, so we had to get a MRI and he had to get a blood transfusion. So I was probably up there from like 9 in the morning till like probably like 5, 6 o'clock.
Okay,
it was like 2 appointments that day. It was long appointments.
Okay, so you weren't there on an emergency basis. You were there for a previously scheduled appointment, correct?
Those were emergencies because he had to that were emergency basically because he had to get a blood transfusion and an MRI because those are emergency basically because sorry.
Sir,
sorry.
Sir, what I'm saying is that
no, those were emergency basis because I had already missed an appointment and then I had already missed an appointment prior to that. So those were emergency basis. Like those were like I had to get to those appointments because he had to get an MRI on his brain because he had brain surgery like a year or 2 ago. So they had to make sure that the surgery was still was doing what they needed to do.
Mr. Cole, I'm not suggesting that what happened wasn't something that was crucial and something that your son needed. I'm not suggesting that. What I'm confirming is that it was a scheduled appointment and you weren't in the emergency room, correct?
No, ma'am. No, ma'am. I was in emergency. No, ma'am. I was on emergency. No, ma'am.
Okay. So you knew the appointment was in the afternoon on the 16th.
It was the morning.
I'm sorry?
It was the morning and the afternoon of the 16th.
You said it was 2 p.m.
No, I said it was 2 appointments.
Oh, okay. Well,
yeah, he had to get a blood transfusion to make sure that I can't really explain how it works, but he had to get a blood transfusion early that morning, and then he had to get an MRI.
I understand that, sir. My point is this: you knew those appointments were scheduled. You did not communicate that with probation when they communicated with you that you could go on the 16th. And knowing that it was 2 appointments, then you should have gone well before your first appointment. And you didn't do that. Why didn't you show up on August 1st for your testing on August 1st?
What day was August 1st?
The day after July 31st. The first 3 months.
She did him dirty. What day was August 1st? The day after July 31st. Yeah, I know. What day was it? Vic, late fee paid for Sir Philip. Thank you so much, Vic. I appreciate it. And Sir Philip, my contribution to the fund. Philip Heels, good to see you. Hopefully you're doing great down under. Hopefully, tomorrow's going to be great. I think you told us, right? Right? Said you're in the future. All right, let's finish this one up.
I didn't understand. I didn't know I missed that every drop I have. I didn't know I missed that day. Every drop I have made, and they've been saying I didn't know I missed August 1st. Every drop, it must have been. I don't understand what day it could have been because every drop I have, I made it, except for those last 2, and they all been clean. And I just dropped like 2 days ago too. And I just dropped like probably like I drop at least if it's not once every week, sometimes it's twice a week.
Pause. Are you still continuing with your treatment and your counseling?
I still go to the classes that y'all have.
The what?
I still go to the class. I still go to the fan meetings and all of that. No, I haven't been continuing my.
Sparkle Poots, thank you so much for the super chat. Wait, there's a fun. Okie dokie then. Thank you, Sparkle Poots. And do you still hear the mysterious Discord noise? I that's been on my mind since last night because I have no idea what it could have been, and I know you're not going crazy. So I'm just like, what? I wonder. I can't think of what it could possibly have been. The weather is great. The weather's actually been awesome. It's been, let's see, mid to high 60s most of the time. It's been absolutely gorgeous. Not hot at all. Not cold. It's been great. It did rain a day, which is good. They needed the rain up here. But yeah, it's been nice so far.
Constantly because my car has been down and it's been too hard to get around.
Okay. What's the status of your license reinstatement?
I have my license.
I believe that was taken care of.
Yeah, I have my license. It's don't have a. It's just my car is over. My car is having electrical problems. Keep overheating, and the shop can't even figure out what is going on. So it's just been frustrating because I thought a simple fix would be. I don't know. I thought a simple fix would have been done by now, and it just not. I don't know.
Dad?
Hold on.
You're fine. You're. That's all. I'm fine.
I understand that. I'm sorry.
What's that called? What was that you said, Mr. Cole?
No, I was telling my son to go back in the house. I'm sorry.
Okay. I mean, it may seem trivial as to what the violations are, but given Mr. Cole's criminal history, the court ordered mandatory jail. Are you okay?
I'm my blood. I have keys.
Go ahead.
Yeah, I know, but that's fine.
Yeah.
Taking these deep breaths.
So Mr. Cole, the court ordered mandatory jail for any violation. And now we're on violations 5 and 6. And the court has suspended a number of jail sentences for Mr. Cole.
I understand.
And many opportunities to get his counseling in order and whatnot. And Mr. Cole knew that there was an appointment on July 16th, did not communicate that to probation. And then again, didn't even go on the 1st. Mr. Cole could have avoided all this violation on his own had he communicated or planned accordingly with the August or July 5th, 16th testing date. Where is it you work, sir?
Paying the party service. I just started my own business, and that's been kind of hard on me too. But yeah, I just started my own business, have my own mobile app storing company, and I've been working there too.
You have your own mobile what?
My own mobile app storing company. I've been working on it for 2 years.
Company?
Yes, I've been working on it for 2 years. I just launched it probably like last month, probably like in the last 2 months. But I've been building on it for 2 years, probably longer than 2 years, and I just launched it last month.
All right, very good. How are you making that mobile if you don't have a vehicle?
I was renting U-Hauls, and that's what was a big deal too. I had to refund the customer. That was a big deal too. That was a big deal too. But I had to book and I had to refund too. But I had to do a U-Haul. Once my car went down, I had to do a U-Haul.
All right, so you could have taken the U-Haul and go to your testing. The court's going to adopt the recommendation. The court's going to revoke probation, close case without improvement, $50 probation violation fee, 15 days jail.
If I go 15 days jail, I lose my job. Is there any way we can charge like anything besides 15 days jail? Like anything I can do besides 15 days, just so I don't mess everything up.
I wouldn't put suspended to 15 days jail. No, excuse me. Let's try to make sure he complies with.
Okay, listen, we have had ultra oversight of Mr. Cole to help him not have to serve his jail time, okay? And so I'm not really sure how much more supervision I'm supposed to be providing to Mr. Cole.
Mind if I sit down for a minute?
Absolutely sit down, yes. And Mr. Cole, you are very much aware as to what was on the table.
Yes,
Very
ma'am.
much as what was on the table.
Yes,
And
ma'am.
so this is the last time that I'm going to have you here on these matters. The court's revoking probation, 15 days jail. And you can report next Friday, so you can communicate with work to schedule the time off.
Next Friday,
September 5th, yes.
I have to go September 5th.
Yes, that way it gives you time to communicate with work about the time off.
Can I do 10 days, ma'am?
So I'm very
Hello?
confused.
Can I do 10 days, ma'am, please? I know they'll probably be more acceptable with 10, but 15, I would lose a lot. I would lose a lot with 15. Can I do 10, please?
Sir, I'm not understanding what you're saying. What did you ask?
I said, can I do 10, please? I could plead with my boss for 10 days, 15. They won't accept that. I understand that. I understand I have done wrong, and I understand completely. I'm just asking if it could be 10 instead of 15. I understand 15 is reasonable too. I understand it. But I would just wonder if it could be.
Have it changed to 10 days. That's fine. That way you don't lose your job, but you're still getting the message, hopefully. And this is the last time that you are going to be at this court, hopefully.
Okay.
Okay.
Thank you.
I cannot believe that worked. Cannot believe that worked. Okay, you say 15. How about 10? I got 10. Can I do 10? Yeah, why not? I mean, now every single defendant should be using this tactic. I'm giving you 1 year in jail. Can I do 9 months instead? I can't do a year, but I can do 9 months. Okay, fine. It just I've never seen that tactic before. I mean, defense attorneys argue that all the time, but it's just weird to hear it coming from a defendant.
Thank you. Have a good day. Good luck to you, sir.
Thank you.
You're welcome. That's so off the record.
Oh, I could have just waited to say my piece. All right, next case. Let's go. Next one is Judge Iorochi out of Ohio. You guys know him, Judge Yelly. Let's go.
Court is on the record in two cases: State of Ohio versus Nathaniel Severino, 25 CRB 259 and 25 CRB 207. In these cases,
yeah, towards the end, he wouldn't be called Judge Yelly if he didn't yell from time to time. So he does yell towards the end of this clip. It's not a long one. It's about an 8-minute clip, I think. So in about 5 minutes, he's going to start yelling. So there's your warning.
Mr. Severino was charged with domestic violence. Actually, 2 counts of domestic violence, 1 in each case. He pled not guilty. We conducted pretrial conferences in the 207 case on July 16th and the 259 case on August 18th. And both cases are now set for a second pretrial conference. Those cases involve an alleged victim named Summer Withrow, and the court is also going to take up 2 cases involving Ms. Withrow as a defendant. City of Conneaut versus Summer Withrow, 25 CRD 208 and 25 TRD 446. In the CRB case, Ms. Withrow pled not guilty to 1 count of domestic violence, where Mr. Severino was the alleged victim. At a July 16th, 2025 pretrial conference, Ms. Withrow did not appear. A motion to continue was filed at that time by her attorney. I granted that continuance and rescheduled the pretrial conference for today. She also has pending a driving under suspension, non-compliance suspension charge, a first-degree misdemeanor in the TRD case, and that as well is set for a pretrial conference today. Now, in the Severino cases, the law director filed with this court on August 22nd, 2025, a motion to allow the witness, that being Summer Withrow, to appear by video, indicating that she is currently in a treatment facility and does not have transportation to attend the hearing personally. I granted that motion, and of course all of these cases are scheduled for the same time, 1:30 p.m. It is now 1:55 p.m. and we've waited for Ms. Withrow to appear, and she has not appeared by video. I would also like to say that in Ms. Withrow's cases, her attorney, Brianna Allen, through the Public Defender's Office, did file earlier today a motion to continue today's hearings involving Ms. Withrow, indicating she is currently hospitalized and not able to be present. So, a lot to consider today. Mr. Severino is present with his attorney, James Shorn. Brianna Allen is present on behalf of Summer Withrow, and present as well is Law Director John Lewis. Mr. Lewis, you're the one who filed the motion to allow Ms. Withrow to appear by video. I'm assuming your office made arrangements with her to appear?
We did, Your Honor. My office communicated with her on the 22nd, as you indicated earlier. Have not had any communication with her since. It is my understanding as well that she is hospitalized still. And this is her second time failing to appear for Mr. Severino's cases. Yeah, second time that she's failed to appear. So the city and state would move to dismiss these cases against Mr. Severino without prejudice until such time as Ms. Withrow is available again. Also, Your Honor, with regard to the CRB case against Ms. Withrow, I consulted with Mr. Shorn, who gave me permission to speak with Mr. Severino. He is the alleged victim in the Summer Withrow domestic violence charge. He is requesting that her case of domestic violence be dismissed as well. All these dismissals would be at plaintiff's cost. And Mr. Severino has also indicated to me that he's also aware that she is currently hospitalized.
With or without prejudice?
Without prejudice, Your Honor. That's, yeah, I would move from all of them would be without prejudice. With the court grace and dismissals. Thank you.
Any objection, Mr. Shorn?
No, Your Honor, we would be in agreement with those motions.
Any objection, Ms. Allen?
No.
The TRD case would have to, will still be pending, and you'll still be representing her, Ms. Allen, on that case, since that is a jailable offense. Do you have the motions?
I do.
Okay. Ms. Allen, before I take action, have you had any communication with Ms. Withrow about her position as a victim or alleged victim in the Severino cases?
I have not.
Okay, I will go ahead and dismiss these cases without prejudice. Costs to the plaintiffs. The traffic case will continue, that being in 25 TRD 446 involving Ms. Withrow. I will grant the motion to continue and we'll reschedule that. Mr. Severino.
Yes, sir.
Let me caution you. Because you had serious felony charges filed against you, and these misdemeanor charges have been filed, and now all of those charges have been dismissed, meaning they could be refiled without prejudice. If you show up in my court again, no, look at me. If you show up in my court again, your bond will be so high, you're not going to be able to do a surety bond. Don't you show up in my court again with charges, especially those involving Summer Withrow. Got it?
Yes, sir.
Okay, these cases are concluded. Anything further, Mr. Lewis?
Yes, sir, thank you.
Mr. Shorn?
Your Honor, as a procedural matter, I'm assuming his bond has been released.
It's a surety. Yeah, all the bonds will be discharged. His was a surety bond.
Yeah, he has the ankle monitor on. What is the
That'll
process in terms
He
of...
can go. We'll have him go to the probation department and see if our probation officer can remove that, or if they need Ohio AMS to come up and do that. So
I
the
just
bail
wanted to know
will.
what the procedure
Yeah,
is.
if you could. Thanks for pointing that out. So if you.
No, not my hometown. This isn't actually the complete opposite side of the state. So I'm from Southwest Ohio. This is in Northeast. This is actually northeast of Cleveland, like the very tip top of the northeast corner of Ohio. And I'm from Cincinnati. I'm from the opposite corner. There you go. Geography lesson. See, sometimes you learn something.
Make sure that.
Sure.
Okay. Ms. Allen, anything further?
No, sir.
Okay. Thank you, guys.
Thank you.
All right. I was told there'd be no learn. Yeah. Sometimes you'll accidentally learn something. All right. I think we're going on to the last case of the evening. We are jumping back into Judge Dad's courtroom, where we have a a very interesting landlord-tenant hearing. This one happened this morning. Let's go.
Manamount versus Concord, 2501975. Mr. Gallup.
Good morning, Your Honor. Creighton Gallup P63002 on behalf of Concord Cooperative.
Well,
I'm in the mouth.
I'm at a loss as to what is going on here. I thought the case was settled, and I'm getting motion after motion after motion, and when people are done filing motions, they're filing more motions. I mean, everything from certifying a class to now motion for protective orders, sanctions for abuse of process. I mean, I don't know what to say anymore. Are you guys settling this or not settling this?
Your Honor, if I could interject here, we have mediated on at least 2 occasions with Judge Hessen, and I'd like to say on a personal note, I appreciate her efforts to try and get this thing resolved. I have submitted to Ms. Mount, this is on a second occasion, a revised agreement that I believe encapsulated.
Yeah, I don't know which dog one that you're talking about, but generally when it has to do with dogs, I don't play it. Unless it's like a dog at large ticket and the person's an idiot, I'll do it. But yeah, when it's I stay away from the animals. Just I'm a pet lover. I'm an animal lover, so it's hard to even from the side of the family. If your dog attacks someone, the trial's on putting the dog down or not. I'm not. I stay away from those. Okay, let's keep going.
The final terms that we had worked out with Judge Hessen after doing a walkthrough of her unit. First one I was denied access, but Judge Hessen facilitated a second inspection. We went in there and we believe we'd worked out a deal. I have provided that to the court administrator, Jen, on Friday, and a copy to Ms. Mount. I have not heard back from Ms. Mount as to whether those terms are acceptable or not. So the ball is in her court. The only motion that we have filed is after the 14th motion was filed by Ms. Mount last week. We just had to put an end to this. We just can't keep up with these motions. A lot of these are evidentiary in nature, and they're not relevant.
These kinds of things. You can raise this at the time of the hearing. Motion to strike police report and certain board member statements as inadmissible, misleading, and tainted by conflict of interest. Motion to preserve rights, objections, and defenses. I mean, I don't want to be rude. It seems like you're enjoying playing lawyer here, and that's okay. But at some point, I'd understood the case was settled. That's what I'd understood. Now I have seemingly I got stacks of stuff here. And I don't know what's happened. Can you just tell me what the basic tenet of the conditional dismissal terms were, Mr. Gallup?
If the court's comfortable with that, because I do know that she had filed a request for a waiver of the jury trial, and I don't want to cause any problems with you if you're going to be the jurist on this one, Your Honor. I can tell you it was a conditional dismissal in general that had arranged for some terms that she would be able to stay so long as the general rules had been followed. I don't want to get into all the specific details, but Judge Hessen worked very hard with both parties to get some middle ground here. I thought this was resolved. I've just not heard back from Ms. Mount from the proposal that was sent to her last week, which is the second draft, which incorporated newer terms for her protection after the inspection that we'd done with Judge Hessen.
Well, do I dare ask what the new terms were?
It specified certain items that we were going to repair in her unit that were basis of her counter complaint, things that she'd said that had been lingering, that had gone unaddressed. It was all going to be taken care of here within the next 30 days.
I don't know what to say. I don't know what to say. I thought it was settled. Did they change something?
No, the habitability was settled, but not the misconduct.
Remind me, What specific misconduct?
Withholding my work order, filing a police report when I wasn't even there.
So,
And it all started after I started enforcing my shareholder rights, for withholding a work order.
can you elaborate on that, Mr. Gallup?
Yeah, she keeps referencing these police reports that are not a part of the court record right now, and that's one basis of one of her motions. I really don't know how to respond to it. It's not a part of the court record yet. She's insistent on having a police report.
File police reports.
I had to do it. There was at least one or two police reports, one of which, when the police were contacted after there'd been a threat made about the site manager, she threatened that she was going to beat her up. And I believe there was at least one other police report sometime where she believes there's conflicting statements from maintenance guys that she wants to call as witnesses. I don't think there's any probative value here, that nothing's been submitted to the court as a part of this. And if this is something that would need to be excluded or included as a part of an exhibit at trial, there are limiting motions and processes that would be handled for something like that. It's very preliminary that she would raise this issue right now. I don't think it's relevant. Regarding the unit itself, she's made claims that her work repairs went unanswered. I think the court knows this. This has been part of the record. There were some delays due to COVID.
Yeah, you know, but that's not right either.
And that's why, and Your Honor, and we have worked diligently with the defendant, and we have worked with.
Do you have time limits in there and the conditional dismissal as to when all these repairs are going to take place?
Yeah, they were already supposed to have taken place last month, but she wouldn't let us into the unit. She changed that. Now it's scheduled, Judge. We'd rescheduled it pursuant to new agreement to the end of September, because it's going to require her and her family.
Slow down. I can't hear. I can't pick up two of you at the same time. You think I can hear you both and comprehend you both? Was a date set for them to come in?
Yes.
Did you let them in?
The first time, no.
Why?
Because I would prefer an extra set of eyes, because.
Did you tell Judge Hessen you weren't gonna let them in the first time without her being there?
No, but
Why did you not let them in then?
Well, because there's bigger issues.
So they're seeking to have you removed. And it sounds to me like you're winning. That's what's befuddling. Hang on. It sounds to me like you're winning. If there's a conditional dismissal, Leonard, they have obligations, you have obligations, but as far as I can tell, you've won.
I understand that, Your Honor, but a conditional dismissal, I've done nothing to deserve a conditional dismissal. I did what I'm allowed to do.
Well, doesn't the conditional dismissal set forth that they're going to undertake all this work? And that there's to be no further violations by you, and as long as there aren't, that will be, the case will remain dismissed? Look, if you guys don't want to settle it, I have no issue with that.
Yeah.
All I know is, I thought it was settled, and it seems like every single or every other third day it just seems like I get motion after motion. I come back from a conference, I got motions after motions here, and I'm thinking, what is going on? I thought we were waiting for a conditional dismissal. Did you graduate from college?
Almost.
Maybe you should go to college and go to law school.
It's not my intention. I have stage fright. Like, this is not what I want to do, but I do know my rights, and I know I didn't do anything wrong. And.
All right. I understood it was settled. Is there anything else I can do to try to resolve this? You're right. If it's not a jury trial, I'm going to listen to the facts, and I'm going to make a determination as to what the facts are and apply the law.
Your Honor, as far as I'm concerned, the ball is in her court. We provided a proposed agreement, a revised agreement. This is at least the second draft that we've given her last week, and I've not heard from her. So if she's telling the court and me today that she's not interested, we got to put this on the litigation track. I'd rather resolve it if we can. My clients come a very long way from where they were at, and it's just very frustrating that all this treasure's been spilt on this. These costs are getting assessed back against the members themselves. This is expensive stuff, so we just need a Fisher cut bait. I'd rather resolve it, but if we have to go to trial, so be it.
Okay. I don't even know where to start.
Well, I can't hear very well, Your Honor. Did Ms. Mount, is she definitively saying she is rejecting what was provided to her last week?
The way it sounds to me.
Okay.
I can tell you you're in the wrong court if you're talking about certifying this as a class action. And then I have other issues that I need to address, like well, how long are you going to be gone on vacation?
I'll be back the 17th, Judge. We do have a preliminary date for the motion that we'd filed, the motion for the protective order. The court had given us October 6th. I know the court doesn't want to put this out further than necessary. I've not received a response to her motion. We just filed it last week. So obviously she would have a little bit of time to respond.
I don't need to decide anymore. There's so many here.
You've only.
I've got packet after packet after packet.
You've made decision on one general motion, which was her motion to transfer,
right.
And we submitted an order.
Motion for reconsideration. I got emergency motion for protective order. I've got motion to preserve rights, objections, and defenses. Notice of waiver of jury demand. Police report is inadmissible upon hearsay. Motion to certify and transfer to circuit court. Motion for class certification. I think there's a couple more in here.
There were still 5 or 6 preceding from the first batch that she'd filed that the court has not had an opportunity to rule upon.
I know. Yeah. I don't even know. All right. Okay. Okay. Well, if you guys don't want to settle, you don't want to settle. I guess we'll just go forward. I will schedule Jennifer?
Yes, Judge.
On a notice going out on all these motions. We're going to set them for October. Was it the 6th that we already set the one with Mr. Gallup?
We gave them the 6th as a tentative date, yes.
Okay. So if okay, let me see here. All right. So I want you to set forth all motions that are going to be heard on that. I want it, I don't even know. So all motions, you're going to separately list each one.
And Judge, for quick reference, if you look at our motion for the protective order, I believe we listed them all for your convenience. I think we listed them. There's 1 through 14. That should help the court.
There's 14 of them?
I believe it was close to 14 that she filed. We've only filed one motion.
I thought there was more. I must be bad at counting. Motion for reconsideration will be the first one on the list. Set them all for October 16th. Any responses are due by
October 6th.
Register, if you would, by September the 29th. Can you do that, Mr. Gallup?
I believe we've responded to all of those, including the 2 recent ones she filed last week. I think.
Match them all up and give them to me, Jennifer. If there's any other ones, you have to respond by September 29th. You likewise have until September 29th, ma'am, to file any responses, okay?
The only other thing I'd ask the court, Your Honor, we've already relied on what we thought was an agreement to get these contractors out there. This is our duty anyway to make repairs. We're going to ask that the court order her to cooperate with any type of necessary inspections in the interim. There are a couple things that need to be done. One is the flooring. The second requires a contractor to come out there and displace them. We'd already made a hotel reservation to put them out. This could.
Who out?
Because they're going to be renovating the bathroom upstairs. HUD requires them to relocate. We've already made arrangements when we're talking with Judge Hessen to get her and her family accommodations if they choose to use them, because they're going to have to rip out the bathtub and replace the flooring upstairs. These are the repairs that were scheduled for August that we rescheduled for at the end of September. If we reschedule it again, this may not happen until October, November, and that'll just.
So wait a minute, when are you scheduled to do the work?
29th, September 29th.
Okay, and you paid for a room for Ms. Mount and her family?
They've already made one arrangement. They're making a second one. They're not out of money until she doesn't show up. We can still cancel. My understanding is we're making another reservation for her for a period of a week. It's possibly a week it's going to take to do the upstairs.
What do you want me to order? Tell me what you want me to order.
That she will cooperate with.
I have no idea. This is just a strange case. Yeah, I don't really have much to say about this, except it sounds like she's winning, but she's still pushing. I don't know. It's not over yet. We still have about, 10 minutes left of this.
The necessary repairs as proposed in the.
If you're going to complain about them not doing repairs, hang on.
Okay.
If you're going to complain about them not doing repairs, you need to let them in to do repairs,
I
right?
understand that, but my children's stuff has been stolen from the last time, so I appreciate it if I could get them out of the house and do it without them worrying, because they're traumatized from the last time.
From what last time?
From our stuff being stolen
When?
from the contractors.
When?
When we were out last time in the hotel for 3 months.
Judge, I don't know what she's talking about. We have never had any reports.
What do you want to? I'm not following you. Do you want them in to do the repairs?
Yes, I did. I just, my kids.
Well, I understand, but do you want to take them to the hotel?
I mean, yeah, I don't have a problem. I just, everybody's showing up at the door. I would prefer just to keep them out of it as much as possible.
Well, tell them, wait a minute. I'm trying to help you here. If you want the repairs done, they have to gain access to the property.
Yes.
So do we have a date for them to come in and effectuate the repairs? He says September 29th.
September 29th.
And she would leave on the night before, because we'll be there in the morning. We make the arrangements for the whole week for her to be staying at the hotel. We'd even change the location to make it more convenient and a newer.
Is that okay?
Yeah.
So you're agreeing to leave on the 28th of September and remain in a hotel until what, about the 5th of October?
Give or take, yes, Judge. That was their projection. And there's one additional.
Wait a minute, wait, slow down. I don't want to hear give or take. I'm not writing give or take in an order. Tell me how long it's going to take, and then she can agree to leave during those days, and you guys can have access to the property.
The contractor assured us it would be done by that Saturday, which was October 4th here. Let me look here.
So you're going to put them up in a hotel until the 5th?
Yes, absolutely. She will not be out 1 cent from that. We will make the arrangements for her. We're required by HUD to provide that to her.
Okay, so I want to make sure this is okay with you. September 28th, the night of your vacate,
Okay.
right?
Yeah.
You come back on the 5th.
Okay.
In what hotel? I want this all in an order.
It's in the proposed consent agreement. It is located off of North Line. It's the new Detroit Townhouses, I believe is the name of it. We've given her the information before. It was Judge Hessen's suggestion. It was a newer location.
Well,
Do you know where? Do you know where?
Well, there was like 2, and I knew, there was 2 different ones.
I just want to know, do you know which 2 they're talking about?
No, Northline Detroit. I thought it was on Eureka.
It may be you're talking by 75. It's right there off 75. It's a new place. I believe it's a Marriott. Just it's on the south side of the road. We'll send her an email, Judge, Your Honor, and if we get done before, we'll be happy to let her know.
Can I put this in an order right now, and then I don't have to worry about this? This is so incredibly petty with so many things going on here. I want the hotel listed. I want the order saying she's going to leave the property to allow the plaintiff to effectuate repairs, which consist of A, B, C, D, E, and F, or whatever they are. And then that she's going to, the plaintiff is going to pay for and relocate her and her family to the hotel at the Marriott or whatever it is on whatever street in whatever city in whatever state.
We can do that. It's already in the order. All I gotta do is cut and paste and I get it to you this morning.
Pull out your order. I have a feeling nothing's gonna go right on this case. If Judge Hessen, if you guys were not allowed access to effectuate repairs, I mean, look, I'm not gonna babysit here. I'm telling you right now, I am not about to babysit. That's ridiculous. She wants repairs, she won't let you in. You guys go in, douse down being told people are stealing things. I'm telling you, I am not gonna babysit. So put it right in your order. Pull out the conditional dismissal and tell me what we're adding in that order. And then I'm gonna order it, and then there's not gonna be any problems. And if somebody doesn't let somebody in, or somebody doesn't show up with the contractor, there's gonna be a serious penalty.
Yeah. So there are three portions of the repairs. The first one requires a contractor and her removal from the property or family. That's the one we're talking about starting September 29th. There's also a flooring issue in the kitchen where the tiles are starting to pop up. That is something that would be done internally. They do not have to be displaced for that. That can be done anytime from now until the 29th. All we would need is her cooperation.
All right, then you're gonna put it in there. The flooring will be repaired on or before September 29th. Defendant / counter plaintiff shall provide contractors hired by plaintiff to gain access for the purpose of repairing the kitchen floor. What else?
The other will happen after, when they'll do painting and they'll do the what they call it, finishing work after the contractor.
When's that going to take place by?
That'll be right after the work that's done.
Let's say by November 1st, sure. Plaintiff shall paint the residence wherever it is, whatever walls, whatever portion of whatever wall, maybe the 13 inches and 1 foot on the east wall, the north corner, but then don't paint anything else. You put this all specifically in an order, and I want it on here right now, please. I'm not going to go through this. This is nonsensical garbage as far as I'm concerned.
I agree.
I mean, you guys, I thought had an agreement, and I'm
Oh, Judge just held himself from saying bullshit. He wanted to. This is nonsensical garbage. Garbage is what I meant. Garbage.
Get motion after motion, and I'm not gonna babysit. They don't pay me enough to babysit.
I agree.
So let's get the order. Let's put all the language in here, because I have a feeling when you submit the order, there's gonna be an objection, and I'm gonna have to have a hearing, and you're gonna be in Italy. And then we're going to delay this, and I'm not delaying it. We're moving forth on this. So tell me, in fact, I want you to draft the proposed order now.
I'm working on it, Judge.
And I'm not, Ms. Mount's not leaving until she looks at it and she approves it, and I'll sign it. You're going to send it to Jen. Jen, tell him where to send it.
Mr. Gallup, you can email me that at jen at.
I'm not doxing the email of his court clerk.
In the hour, probably the next 20 minutes, actually.
Thank you very much. And then Ms. Mount, we're going to print out the copy of the order. I want to see it too, Jen. So when you give her a copy, I want to see a copy.
Yes, I'll print a couple copies and bring them down as soon as I get it.
Thank you very much. Thank you.
Judge, if I may, before though, they go, what time on the 6th for these motions? Do we want to do the afternoon or late morning?
What day of the week is that?
It's a Monday.
Well, I probably have sobriety for it, right? Don't I? Let me think. 25th, 8th, 22nd, the 6th is a Monday. Why don't you set them at 1:30 on Monday the 6th?
Okay.
Okay?
you.
Thanks.
Okay, Judge, let me get working on the order. Do you want me to pop back into the Zoom after we've sent it to you, Your Honor?
I do. I want you to send it to Jen, and then you can wait 10 or 15 minutes. She can look at it. I'll look at it. And if there's corrections to be made, we'll make them, okay?
It's only gonna be about the repairs, and she's gonna cover just the one portion, so we'll get to you here.
Just be specific. I want to know where she's staying. Everything. Okay?
Thank you.
Thank you.
See you.
Oops. I'm sorry, guys. I thought there was still like another 30 seconds. I knew that the video was almost over. I just didn't realize the outro was popping up that quickly. All right, well, I mean, that's it. That's all I got. I don't know if the outro gave that away, but they did come back about, I don't know, 30, 45 minutes later. I didn't want to play that. That was, all they did is walked up and was like, is this okay? Yep. You agree? Yep. You agree? Yep. Okay. I don't want to hear anything else. That was about it. But it did, the way that court works, that took 5 minutes. Anyways, thank you guys so much for hanging out with me tonight. I do appreciate it. Thank you for the super chats, and thank you to the mods. As always, you guys are awesome. I will see you guys tomorrow. There's a busy court docket tomorrow. I've got, I think, 5 cases on the calendar for tomorrow. Got, I think, 2 soft sits and then a couple random follow-ups, but 5 cases tomorrow. It's gonna be a good day. It's gonna be a good day. A lot of content. Jen, thank you so much. Late fees accrued to date. Thank you so much, Jen. I do appreciate it. Thank you for the super chat. Hopefully you had a great night. All right, you guys are awesome. I will see you tomorrow. Oh, we're rating Katie's Head tonight. Booze and Body Cam. It's Wednesday. I can't remember which one I rated last, so I just picked one. So we're going to Katie's Head. KFAR is also live. Lone Wolf's also live. So I will. Yeah, that's it. That's all I got. I'll see you guys tomorrow. Okay, bye.